Okay, now we move on to our second topic, which is Companies Act 2016. Right, so in this chapter, we are going to study section 261 until 277. So 261 is actually related with auditor statement. 263 qualification. 264 is disqualification. 266 is related with duties and power. 267 is actually related of the appointment of private company, appointment of the auditor. 271 appointment of auditor of public company. 274 fixing of the remuneration. 281 resignation. 282 notice the resignation to the ROC. And then 283 is resigning auditor of a public company. And 276 is to remove the auditor from the company. And 277 is actually relates with a special notice for resolution to remove auditor from the office. Right, so now we move on one by one. Section 261, so auditor statement. So auditor statement, it means that here what are the statements that the auditor should come out. Number one, a company shall lodge to the registrar or ROC that the auditor statement related to financial statement which include the following. So it means that here the company must send the report to the ROC. So in this report, it should conclude stating all this kind of information. Number one, that the company has kept proper accounting record and other books. So it means that all the record that should be properly kept by the company. Number two, stating that the financial statement has been been audited according to the Companies Act. And then also it must stated the accounting standard, right, has been followed, and also the auditor in arriving the audit opinion. And the next one, it also must stated that the ability the companies to meet its liabilities when it come due. So it means that they are able to pay all their liability. All right, so if the company fail to present the report to the ROC, so the company may be fined more than 20,000. Right, so if they are continuing doing the same problem, so what they have to be fined is actually 1,000 ringgit for each day after conviction. All right, according to section 263, so this is related with the qualification of the auditor. So how the auditor can be qualified? So number one, it should be approved by Ministry of Finance, and then should be have a good character and competence. So it means that you are knowledgeable enough. And then the next one, you should have necessary qualification or required qualification. So the MOF will renew for every 2 years for the to become a so this one will be renewed for every 2 years for the auditor. All right, so appointment can be name of the auditor by their name itself, or also it can be appointed as audit firm. So it can be the name on the person, or it can be on the firm itself. Right, so next one, the auditor must give consent in writing to act before appointment. So it means that the auditor must give consent first before they act. All right, so section 264 is actually the auditor, so who's disqualified to become the auditor. So number one, he is not an approved company auditor. It means that which is not stated in section 263 above. Okay, and then if you indebted, so it means that you borrow the money from the company or the subsidiary company that relate with the company that you are audit, amount exceeding 25,000. All right, you are also disqualified to become the auditor if you or your spouse is an officer of the company that you are going to audit. The next one will be you or your partner or your employee or your employer is actually the officer of a company. So it means that you have your own firm. It doesn't matter you, your partner, your employer or employee, is actually of an officer that relate with the company that you are going to audit, so you are disqualified. All right, so the next one also the same, a partner employee of an employee of an officer, okay, of the company. So the next one, whether he is a shareholder or his spouse of a corporation whose employee is an officer of the company. It doesn't matter whether you is a shareholder or your spouse is a shareholder of that corporation. So you also are disqualified. So the last one is you also cannot become the auditor if your partner, your employee, or your employer is a person who responsible keeping for the registrar of members and debenture holders. So this one refers to the secretarial company. So it means that here, your company, which is relate, whether your company, your partner, your employee, your employer, right, which relate to keep the members of the company that you are going to audit. So basically this one will be recorded, will be kept by the secretarial company. So normally you know that the secretary is actually for a boss, but now secretary is a company to a company. Okay, so they also disqualified to become a auditor for that company. All right, section 264, we continued here. So if you undischarged bankrupt within or outside Malaysia, it doesn't matter. So it means that you have been charged or you still being declared bankrupt. Okay, so he has been convicted for any offense, fraud or dishonesty, so punished with 3 months or more imprisonment. So it means that here, same also, if you are being charged for this one, you also cannot become the company auditor. So next one will be if any of the partner is disqualified. So it means that here, your partner is disqualified, all right? So section 265, notification. So it means that here, if all those report you are not sent to the SSM. So registration of firms of the auditor has not lodged to the SSM, so cannot. All right, section 266. So this is the duties of the auditor. So what is the auditor's duties according to the Act? Number one, you as the auditor, you should report to the members on the financial statement. As we know, the auditor is appointed in order to report to the members of the financial statement. So where they have to report? For a public company, they have to report during the AGM. For a private company, so all those information should be informed to the members or circulated to the members. So during the meeting of the members. All right, so next one, 266 sub 2. So the auditor should include in his report, number one, whether the financial statement in his opinion is properly drawn up, give true and fair view as required by section 248. And then the next one, in accordance whether it's give true and fair view. And the next one, whether all the financial statement is accordance with the applicable accounting standards. So these are the three parts that the auditor should come up in his report. All right, 266 sub 3, we continue. So what others or the auditors have to report? All right, in his opinion, the consolidated account financial statement where applicable have not been drawn up in accordance with the applicable approved accounting standard. So if you are auditing for the if you're auditing for a consolidated account, so you also have to come up with this report. All right, so and also you have to disclose the name of the subsidiaries. For example, if you auditor of the holdings, so you also have to name it of the subsidiaries company that even though you are not the auditor. All right, so duty to report to any defects, irregularities in the account. So any defects or irregularities item, So you have to inform. All right, so next one, E, if not satisfied to any matter, A, B, C, so you have to provide for the reason. Okay, so you have to state why you are not agree. All right, section, so we continue again, sub 3. So auditor's duty to perform an opinion to each of the following matters. All right, number 1, you are able to obtain all the information and explanation that you need. So it means that you are not restricted to get any information that you want. And then to ensure proper accounting and other records have been kept, right? So you get you already sure that all the records is properly kept by the company. All right, next one, to ensure that the procedures and method used by the holding or subsidiaries were applicable to the circumstances of the consolidation. So it means that here you have to know the holding is using what method. For example, I give a specific example in terms maybe a method of depreciation, all right, maybe for the provision of something. So they have to consistent from the holdings and the subsidiary. And next one, to ensure the return received from branch officers of the company are adequate. So it means that here when you ask the information from the branch, what you get, the information is enough for you. All right, 260 is actually powers of the auditor. So we continue for the powers of the auditor. Okay, 4 until 7 is relates with powers. So what are the power that the auditor has? So 266 sub 4 has the right to access all information or at reasonable times the accounting and other records. So it means that you have the right to get all those information, all those records that you want. All right, 266 sub 5, so it's stated here, auditor of the holding, so for which consolidator is required, all right? So if you are the auditor of the holding, so you have the power to assess all the reasonable time or any time the accounting and other records of the subsidiary. So it means that here if you audit the holding and then you have the queries of the information from the subsidiary and then you need all the information, so you have the right to get all the access of the information. All right, next one, 266 sub 5. Next one, the require from any officer of the auditor of the subsidiary. Just now you can get the information from the subsidiary company. This one also you can get the information from the auditor of the subsidiary. All right, 266 sub 6. So it means that auditor report shall be attached on the financial statement, can be read during the AGM. All right, should be attached. All right, 266 sub 7. You have the right to attend any general meeting, right? So you, for example, you would like to attend for any general meeting, you have the right, all right? And then to receive all communication that as a capacity of the auditor, all those communication, you have the right to access also. You have the right to receive all those information also. All right, section 267, so it relates with the appointment of the auditors of private company. So private company shall appoint auditor for each financial year. So it means that every year you have to appoint an auditor. All right, 267 sub 3, so the board is actually able or can appoint the auditor for a newly incorporated company. So it means that the company just established, so the board can appoint an auditor when at least 30 days before the end of the period for the submission of the financial statement to the ROC. At least 30 days before you submit, you can appoint. The board of director are able to appoint. And then also the members also can appoint in the subsequent year. So it means that the first year, the auditor can appoint, but for second year, members or the shareholders may appoint. All right. So, and also if the board fails to appoint under sub 3. So it means that just now, if the board do not appoint, so the members can appoint. All right, Section 271, appointment of the auditors for a public company. Just now is for private, now is for the public. So the powers of the directors to appoint auditor before first AGM. So the directors have the power, all right. If the directors do not appoint the first auditor, so the members are entitled to do so in the general meeting, all right. So the first thing is the directors can appoint before first AGM, but if the directors do not appoint before first AGM, but after that, if still directors do not appoint, the shareholders can appoint. When? During the general meeting. So this company auditor should be appointed in each AGM. It doesn't mean that you have to change another auditor, but even though the same auditor, you have to keep reappointed on each annual general meeting. So it will hold the office until next AGM. All right, next one will be power to the directors to appoint auditor to fill any casual vacancy. So it means that here, if there is a termination, right, for example, for winding up the cases, so the company is going to be closed or dismissed or removal of the auditor, so directors may appoint. All right, for section 174, fixing of the auditor's remuneration. So it means that how the remuneration of the auditors will be fixed. So it depends on the appointment. So by members, so the remuneration will be fixed by members if it appointed by the members. So if the auditor is appointed by the board of directors, so it's going to be fixed by the board of directors. And if it's being appointed by the registrar, so the ROC can fix for the remuneration for the auditor. All right, section 281, resignation of the auditor. So auditor may resign. How? So they must give notice, right, within 7 days, all right, and then auditor may resign. So I state here, a notice to the company at the registered office within 7 days of serving such notice, submit to the SSM his reason for resignation, right? So within 7 days, you can give the notice to the company that you like to resign, and they have to forward to the SSM. So, all right, next section, sub 1. So the company tend to send a copy resignation notice to the SSM within the 7 days of the receipt. So within 7 days, what I said just now, they have to submit to the SSM. So resignation of the auditor will valid within 7 days of serving the notice of the registered office. Okay, so when the auditor resign, so they send the notice to the company. So the company, so after 7 days, they have to send to the SSM. So after 7 days also, they receive the communication from the SSM. So after 21 days, so this one will take effect. All right, section 283, right of resigning auditor of a public company. So the auditor must give notice. So this is for the public company. All right, so auditor must give notice of resignation with a statement of circumstances. All right, so request the directors convey a general meeting. So this is a public. So they have to come up with the general meeting. So within 28 days for the shareholders to receive the explanation of the circumstances connected for his resignation. So it means that they have the 28 days to make sure that the shareholder will receive the explanation. All right, section 276, so resolution to remove the auditor. So the two section A is actually the auditor is willing to resign, but section 276 is actually they would like to remove, right? So the members of the company or the shareholders of the company can remove the auditor from office at any time. So number one, by ordinary resolution at a general meeting. So just like normal, in the meeting, they will discuss to remove the auditor in accordance with Section 277. So in Section 277, so special notice 28 days to be given by the shareholders for removal of the auditor, and the company or receipt of the same must immediately send a copy to the auditor proposed to be removed to and to SSM. So within 28 days, they have to inform the shareholders intend to remove for the auditor. So the auditor may make representation within 7 days from receiving the special notice. So after he receives the notice, within 7 days, he can write, something maybe to back up himself, all right, because he's going to be removed. All right, the auditor may require that the representation be read out during the meeting. So it means that all the representation that he wrote can be, that one can be read in the meeting. So he can require that one should be read in the meeting. All right, Section 277. So special notice required for resolution to remove the auditor. So we continue Section 277 here. On the passing of the resolution by way of meeting of members for the removal of the auditors, right? So the company shall notify SSM within 7 days. So within 7 days, they have to inform to the SSM. So private company cannot use members' written resolution for removal. So this one is only for public company. So the company shall fill the vacancy created by removal of the auditor in general meeting. So it means that if they already decided in the general meeting, they would like to remove the auditor. So it means that in the general meeting also they can fill up for vacancy. All right, there is no need to lodge to SSM to report to the SSM of the resolution passed for the appointment on the new auditors because they already did in the general meeting. All right, last one, the auditor appointed to fill the vacancy of the removed auditor will hold the office until the next AGM. All right, for a public company or 30 days after the circulation of the financial statement. And last one, the SSM will appoint an auditor for the company if the company fails to appoint one to fill the vacancy so created. So it means that here, if the removal of the auditor, right, the company do not appoint, so the SSM will take action to appoint an auditor of the company. All right, thank you. That's all for the topic 2 of the Companies Act. Thank you.